seated. We'll go on and call the docket for the second case we have this morning. 07-24-00251-CV Mission Clay Products LLC versus LA Fuller and Sons Construction Limited for the appellants.
Good morning, Your Honor. Russell Hollenbeck and Landon Francois for the appellant Mission Clay Products. Mr. Francois will present our opening arguments, and I will present our rebuttal argument.
So you're going to be doing the 20 minutes, Mr. Francois.
That's correct, Your Honor.
Very good. Very good. Thank you. And for that, please.
Your Honor, Tom Riney and Blake Crossnow for the appellees. Mr. Crossnow will be presenting the argument.
Thank you. Mr. Francois, you have to. I'm going to ask you a favor, kind of direct the mic towards you. There you go.
Is that coming through okay?
Can you hear back there?
Okay. I'll try to project regardless.
Please.
Thank
My wife
you.
would be proud of you if you project. That's not what she told our kids to do. Learn how to project.
Thank you, Mr. Chief Justice, and may it please the court. This is a straightforward contract case in which Fuller purchased a substantial quantity of pipe from Mission Clay and agreed to indemnify Mission Clay for financial losses caused by Fuller's negligence or Mission Clay's. Fuller now seeks to escape that obligation. In the trial court, Fuller put on several arguments in support of its summary judgment, but on appeal, the parties have narrowed it to two: whether or not the indemnity provision satisfies the fair notice doctrine, and whether or not the contract is valid under the statute of frauds. I'd like to focus my argument today on those two main issues, addressing them in three parts.
Escape the obligation, in your view, is that escape indemnity in toto or escape indemnity vis-a-vis any wrongs that may have been caused by the manufacturer of the pipe?
Your Honor, the way that we read Fuller's trial court briefing, the way that the trial court ruled on summary judgment, and the way we read their appellate briefing, it's in toto. They seek to avoid any indemnification obligation based on a lack of conspicuousness and based on the express negligence test. And those kind of will make up the first two components of my argument today. And then there's also a third argument they've raised, that the entire credit agreement is unenforceable under the statute of
So the
frauds.
conspicuousness allegedly applies to every indemnity agreement.
That is correct, Your Honor. As recently, in 1993, the Texas Supreme Court kind of in Dresser unified what had been multiple cases that talked about conspicuousness, about express negligence doctrine, and effectively said risk-shifting provisions as a matter of public policy need to be conspicuous and they need to be expressly written so that they state what their intent is.
So we have two issues: conspicuousness and then separate issue, express negligence.
Effectively, yes, Your Honor. Under the fair notice doctrine, indemnity provision needs to meet both elements. It can't just meet one really, really well and not meet the other. So it is kind of one issue, but it's split up into two subparts. And then, of course, the issue of the validity of the contract generally. While in the trial court, there was also briefing as to the indemnity provision being part of what they called an illusory contract. And there was also some argument that Mission Clay could not seek indemnification for a settlement after the fact. Those arguments appear to be dropped by Fuller on appeal, and so we don't intend to address that in argument unless the court has questions, but we have addressed them in our briefing.
Just curiously, to follow through what I was asking earlier, if, assuming arguendo, we say they meet conspicuous but not express negligence, you get some indemnity for some claims?
Well, Your Honor, that depends. There's a diversity of case law on that. Some cases have kind of said that under the express negligence test, the real risk shifting is if they are required to indemnify Mission Clay for any of Mission Clay's acts. Other courts have kind of taken a different approach and said, well, if it's not entirely clear from the indemnity agreement, we're going to throw the entire thing out. And so under these circumstances, though, I want to make it very clear at the outset, Mission Clay is not seeking indemnification for any acts that are solely the responsibility of Mission Clay. And we do not contend that the indemnity provision requires that. In fact, we contend that twice in the indemnity provision, it disclaims that. We are only seeking indemnification for acts that Fuller was complicit in or part of, that there was not just sole negligence on the part of Mission Clay or a sole act on the part of Mission Clay.
At what point is that determined? Was that determined according to your position at the time the settlement agreement was reached? Was that determined, is that to be determined in the future? Or when do we assess who's responsible and for what?
Absolutely, Your Honor. So Mission Clay's request from this court and its request in the trial court was for one thing, and that is a jury trial in which a jury would go through the claims, they would determine the causes of action the city brought, and they would assign responsibility to the various parties. That would include Mission Clay, that could include the city, that could include the city's engineering firm, Brandt, and then of course that would include Fuller. So if the jury were to go through the causes of action, if the jury were to say, yes, various parties were negligent, we're going to assign responsibility among them, if that would be the step at which that needed to be determined at a trial on the merits on these actual causes of action. And the jury there would also be tasked with reviewing the settlement that Mission Clay entered into with the city. So the jury would determine, was the settlement fair and reasonable under the circumstances? So if the jury determined, well, Mission Clay didn't actually have a responsibility here, it shouldn't have settled its claims, that would be a question for the jury as well. So it's not the fact that simply by having some percentage responsibility, Fuller now has to pay the entire settlement. That's still a fact question that the jury has to address at a later date. So our requested remedy here is what we asked in the trial court, and that's just to go to trial on these claims, to evaluate the responsibility of the parties.
Let's talk about conspicuousness. Why do you think that the indemnity provision is conspicuous? I noticed when we're actually looking at the actual contract, the disclaimer of warranty section, for example, is set off with bold, underlined, type, et cetera. Maybe there's an argument there that can be conspicuous, but indemnity appears alongside of ordering and force majeure clauses and severability and other things that all appear to be formatted the same. So why would that make it conspicuous?
Yes, Your Honor. So when we evaluate conspicuousness, the Texas Supreme Court has told us that we adopt the definition as set out by the Texas Uniform Commercial Code, the UCC. And so in section 1201B, there are various definitions, including one for conspicuousness. And in that section, the UCC specifically sets out what are examples of conspicuous terms. And the first thing it says is any term that has a bolded or otherwise set off heading that is distinct from the text is presumed conspicuous. And here we have exactly that. We have a heading that says indemnity. It tells the reader exactly what this provision is about. And it is bolded, it is in uppercase font, and it meets the definition of conspicuousness as the Texas Supreme Court adopted in Dresser, and as the legislature has adopted via the UCC.
Let me ask you a hypothetical. When I was driving up here today, I went through 3 different construction zones. One of the things I noted about the construction, I did slow down, yes.
You had to rock your legs
I slowed down some. One thing I noticed about going through those construction zones was they were conspicuous because the sign color changed to orange. We added cones, there were flags, there were flashing lights saying, slow down, this is something that's different from the regular roadway. If we adopt your argument, it would sound like it would be the equivalent of saying we can paint all road signs orange and put flags on them and lights, and that everything would be conspicuous. It seems to me more like conspicuousness really depends on the context and not simply whether it's got bold type or is offset in a certain way.
You know, I would agree with you that there is a context-specific evaluation. Conspicuousness is a question of law for the court to determine, but it is very fact-intensive, and each agreement may have different characteristics. So while I would agree with you that under very certain circumstances, perhaps a bolded heading may not be conspicuous, I think that Fuller has pointed this court to the JCPenney case out of the Texas District Court, which a magistrate judge said, yes, there is a heading that says indemnity, yes, it is bolded, but I do not find this conspicuous because the factors there were it was on the back of a purchase order, it was one of multiple unrelated terms, and the purchase order itself was so thin and translucent and the text so fine that it was virtually impossible to read. Now, the difference here is we do meet the textbook definition of conspicuous under the UCC. And we do not believe that there are additional factors like those in the J.C. Penney case, like those in the Mundy case that Fuller also relies on, that undermines that conspicuousness.
How is that supposed to be determined then? When you've got a situation like this where the formatting for the other context in the contract is about the same? If we can say, we agree, this is the document we're all looking at, then that seems to be an undisputed fact. Is determining conspicuousness a question of fact or a question of law then, when you've got an established set of text?
In Your Honor, I struggled with this when I was reviewing the briefing. It is very clear the Texas Supreme Court and the UCC both state explicitly, expressly, that conspicuousness is a question of law for a court. It is not a question for a jury. It is not a question for a fact finder, with one narrow exception, which I'll get to in a moment, and that's if a party has actual knowledge or actual notice of the conspicuousness of the indemnity provision itself, which we do believe there's evidence of that here, which is another reason that there should not have been a summary judgment granted.
Real quick, opposing counsel with regard to your last argument says that was never raised in your response to summary judgment or along those lines. Was it?
Yes, Your Honor. It was raised in multiple points throughout both. If the court may recall, the procedural history of this one's a little weird. Mission Claim moved for summary judgment. It was actually granted that the indemnity provision was enforceable. Then after all the settlements occurred, Fuller moved for reconsideration of that. There was briefing, substantial briefing on that, and eventually the court then essentially granted a cross motion saying, well, it's actually not an enforceable indemnity provision. But in, for instance, Mission Clay's original summary judgment briefing, they raised that Fuller had the ability to read the contract, made material modifications to the contract, made material modifications to the credit agreement, and that showed that the provisions were all legible, readable, and they were conspicuous.
Well, the modifications were on, to the credit agreement on a different page, right?
They were on a different page, Your Honor, yes. However, there are other facts in the record which indicate that Fuller received and reviewed all of the pages of this, and we don't believe that the cases, to create a fact issue, we don't believe that the evidence needs to show a modification specifically to the indemnity agreement. It just needs to put on some evidence that Fuller was able to review these terms and was actually looking at them.
That he could review it allows for the inference that he did review it?
So that's not true, Your Honor, because of course a party can review any contract they sign. No, and of course courts have rejected that simply signing a contract is not enough. But here, this is not just signing a contract. What we have are essentially 2 pages of terms. On one of those pages, Fuller made multiple modifications to the specific nature of the party's agreement. And then on the second page, both pages, the credit agreement and the general terms at the top have a paragraph that say there are several terms and conditions that will apply to all transactions between the parties. Fuller actually filled out an entire application on the first page of this. It was not just a passive signing of a contract. This was an endeavor that Fuller, as president of the company, undertook to read the terms, to modify the terms, and then return all of the pages to Mission Clay. This isn't
The chief asked you just a minute ago about whether there was briefing on this at the summary judgment stage. I'm going to ask you a similar question. Is this not a confession and avoidance type argument that had to be pleaded?
No, Your Honor. So you can plead actual notice, actual knowledge, and you can actually move for summary judgment that a party, there's conclusive evidence that they had actual notice or actual knowledge. However, as the non-movement on Fuller's motion for summary judgment that the indemnity provision is not enforceable, we only had the burden to raise a fact issue. And there's several cases that have said this. The American Home case that's cited in our briefing out of Dallas in 2006 evaluated a similar issue. It said, well, it was not a pleaded affirmative defense of actual notice or actual knowledge, but you raised fact issues, so we're going to address it here. They ultimately determined that there wasn't sufficient evidence to find a genuine issue of material fact because their only argument was a signing of the contract. But that still stands for the proposition that it's simply enough to raise it as a fact issue to preserve the error on appeal. Additionally, more recently—
Your argument, though, is that to the extent it's clear they read part of the contract, that's enough evidence to reasonably infer that they read all the contract.
Yes, Your Honor, and it's not just that. It's not just the reading of the contract. For instance,
But they have to read the contract in order to see the indemnity provision, and that's kind of what you're relying on.
Sure, yeah, yes, Your Honor, that is true. But for instance, just last year, the Houston 14th Court of Appeals, there was a case called DeCero out of that Court of Appeals. It's also cited in our briefing. In there was an indemnity provision that was actually incorporated into a contract. The contract said, please see our website for additional rules, which included an indemnity provision. And the court actually determined there was a fact issue as to whether the party had actual notice of that, even though it was not conspicuous in the document because it wasn't in the document. And the reason is that they saw that DeCero had complied with other parts of that rule agreement that was on the website, or had done other things in accordance with those rules that at least raised an inference that they probably had awareness of it and actual knowledge of it. And
We started out discussing conspicuousness under the definition under Article 1 of the UCC.
Yes, sir.
Is actual notice also a part of the statutory provision, or is that something that was created in the common law later on with the judges saying, yeah, but if you have actual notice, you don't have to have a conspicuous provision?
So the actual notice is a creature of case law. In Dresser, there's a footnote that says conspicuousness is not required if there's actual notice or knowledge. The Supreme Court took that up again in Reyes in 2004, but then several subsequent cases have evaluated that footnote from Dresser as an exception to the general rule of conspicuousness. And just to briefly go back to your initial question about kind of this disclaimer of warranty, one of the reasons for the difference is that the indemnity provision's conspicuousness requirement is this creature of case law. That's an imposition by Texas courts under the Fair Notice Doctrine. It's not actually part of the UCC. In contrast, disclaimer of warranty is expressly stated in the UCC, and the UCC tells you how you need to state that in a contract. So while an indemnity provision, it doesn't say how you need to write a contract to include that, that's an issue specific to Texas law and how Texas courts evaluate that. So that's one of the reasons why there's a difference between those terms. But that, simply because one term is more conspicuous in a document, doesn't render the other one inconspicuous. We contend that the indemnity provision still satisfies the requirements of the cases. It satisfies the requirements of the UCC. We have found no case, and I don't believe that Fuller's counsel has found any case, in which on single-sided agreements, there is a bold uppercase heading that says indemnity, and a court determines that that is not enough for conspicuousness. That, the Supreme Court in NSEARCH said that that's enough. It was a similar case where there were multiple provisions, one after the other, and that one was actually on the back of a contract. They said that there was enough that there was a paragraph on the front that said there are terms and conditions, and then on the back, the indemnity provision had a bolded heading. It said indemnity. In contrast, the other cases mostly relied on by Fuller, such as Mundy, JCPenney, these are also back of purchase order cases. And courts really disfavor conspicuousness indemnity agreements if they're found on the back of something. But that's not what we have here. Here we have a single-sided agreement that was faxed to Fuller. And we know that Fuller received every single page of this agreement. We know that Fuller reviewed every page of this agreement because Fuller actually faxed every page back to Mission Clay. It wasn't just that he faxed back the signature page. He faxed back the application, the signature page, and the general terms and conditions. And the fax document in the record at 1657 and 1658, if you look at the fax stamps, it actually shows that the terms and conditions was page 5, and the signature page was page 6. So it's unclear what order he received them in. But what that at least raises is a fact issue as to whether or not he reviewed these terms of the contract. If he's making very precise edits and modifications in the credit agreement, to say it doesn't even raise a fact issue as to whether he looked at the general terms and conditions, we don't believe that that's correct. We've found no case in Texas that has rejected actual notice when parties have made modifications to contracts. Most of the cases that reject it are when a party only alleges a signature on the document. But again, I urge the court to look at the DeCero case from last year out of the 14th Court of Appeals. In there, there's not even very strong evidence that they looked at each individual provision. It's just whether or not they looked at the rule book that contained the indemnity clause. That was enough to get us to a jury. And so ultimately, we just want to get to a jury on all of these disputed issues of fact. In the time I have left, I'd like to briefly address the express negligence doctrine. Fuller primarily relied in the trial court and on appeal on 2 cases on the express negligence issue, and that's this court's opinion, Oliver from 2018, which is actually Chief Justice Quinn, your opinion, and then a case out of Dallas that's called the Rogers-O'Brien case. Just to quickly set apart our case from Oliver, in Oliver, the parties were talking about sole negligence indemnification. I don't think either party thinks that that's at issue here. The indemnity provision here expressly omits Mission Clay's sole negligence from any requirement of indemnification. It's the last line. Fuller's duty hereunder shall not arise if the cause is Mission Clay's sole negligence as determined by a court of law. So this is not like Oliver, in which the issue was whether Oliver, there was no allegation of negligence whatsoever, and their indemnity provision had specific language that only required indemnification to the extent that Oliver was negligent. The language is different, the facts are different. We don't believe that that case's holding applies here. And as another distinguishing factor, in that case, this court actually granted no evidence summary judgment as to claims against Oliver because there was no evidence of Oliver's negligence. Here, Fuller hasn't even moved for summary judgment on its negligence, never moved forward in the trial court. It's not before this court. And then just lastly, on the statute of frauds issue, we believe that the statute of frauds can't invalidate a contract after performance occurs. That's 2201 of the UCC, subsection C, specifically states that. You cannot avoid a contract on the statute of frauds for goods already paid for and received. There's no dispute among the parties that all of the pipe that Fuller requested was paid for and received by the parties. There's no dispute about that point. And so we'll address any of the court's further questions in rebuttal. Thank you.
Thank you.
May it please the court, counsel, before I dive in and start talking about the specifics of the fair notice test, I think it's important to pause and remember the reason we have that test. This court has said that indemnity provisions are strictly construed under Texas law, and there's a good reason for that. Agreements purporting to indemnify a party for the consequences of its own negligence represent what the Supreme Court of Texas has called an extraordinary shifting of risk. So you have to show both conspicuousness and that it complies with the express negligence test in order for it to be enforceable. In this case, the indemnity provision does not comply with either prong of the test and is unenforceable. Now,
Do you agree with opposing counsel that conspicuousness and express negligence rule, where conspicuousness applies to all indemnity agreements, not just those where you're trying to indemnify against your own negligence?
Yes, I agree with that under the case law. And it's a term that is defined by statute and to mean so written, displayed, or presented that a reasonable person ought, which it is to operate against, ought to have noticed it. And in this case, the indemnity...
What is your argument in response to what opposing counsel said just a minute ago, which is that the definition also says that if it has bold type and meets the formatting requirements, there's a presumption that it was conspicuous?
The definition does refer to bold type. And if you look at the comment to the statute, it says, the test is whether attention can reasonably be expected to be called to the provision. The statutory language should not be construed to permit a result that is inconsistent with that test. And I think this goes to some of the questions you were asking earlier. When everything on the page where the indemnity provision looks the same, there are 18 other provisions on the same page, all crammed on the same page, all have the same heading, the same the text and font size and everything else. When everything is the same, nothing is conspicuous. And I'll give the court an example. somewhat local. If you go to a Texas Tech football game and everyone in the stands is wearing red except for the other team, red is ordinarily a conspicuous color. It stands out. But if everyone is wearing red, then nobody sticks out. The only people that stick out are the people who didn't get the memo and show up in a burnt orange shirt or the other team's colors. So
You're looking at differentiation.
right.
Okay. Differentiation is the microscope or the looking glass. Bold type, coloring, different font, things. Those are factors that go into differentiation, but overall it's still differentiation, making it conspicuous from everything else.
Right. And I think that's the key point. And there's only one provision on this page that is conspicuous at all. It's the disclaimer of warranty provision. It's set off with a blank line above it and below it. None of the other provisions are that way. The indemnity provision is not. It has a bigger heading, a heading that's underlined. It has bigger text. It has text that's bolded, and most of it is in all caps. The indemnity provision has none of that. It's also on the 4th page of a 4-page agreement. This isn't a one-page agreement or an agreement that's on 2 sides of the same page. It's 4 separate pages.
Would you agree with opposing counsel that that presents a question of law versus fact on whether a portion of a contract is conspicuous or not?
Yes, it does under the case law, and it makes sense when you think about it because it's a legal document. You look at it, and the court can look at it. What it says and what it looks like are not at all in dispute, and it's for the court to look at and determine whether objectively or reasonable it would be conspicuous. It definitely is a question of law. And the other thing, whenever you're getting ready for an oral argument, you always come across something and you say, I wish I would have said that in my brief. And one thing I wish I would have said is that it's somewhat surprising to begin with to think that there would be an indemnity provision hidden in a credit agreement. To have an indemnity provision that talks about liability from future sales of goods and how that will be allocated and future injuries or property damage.
Why would it be? Why?
Well, I mean, if you have the actual sale of the products or goods, which comes later in this case, you would be perhaps looking out, okay, well, what's going to happen if something goes wrong here? But here, this is just allowing the sales to happen in the future. It's a credit agreement.
That's talking about how you pay, and that's pretty important.
That's important, but it's not related to the question of how liability is going to be allocated down the road. So I know they're focused on, yes, there was bold and headings and it was all capitalized, but it was not conspicuous compared to the rest of the other provisions in the agreement. And we cited several cases, including some of the cases the Mission Clay cites in their brief, where the courts have said this has to be a comparative analysis, that you don't just look in the abstract whether the red shirt in the crowd is conspicuous. You have to look at the setting of it, which is the comparison to the other provisions in the agreement and on the same page. And we've cited the Henry Key Equipment case and the U.S. Rentals and Monday Services court case and the J.C. Penney case for that proposition. It's a comparative analysis. And when you look through everything on that page, there is only one provision that's even arguably conspicuous, and it's that disclaimer of warranty provision. It's not the indemnity provision. So we've also cited for the court several cases that we think support our position. One is the U.S. Rentals versus Monday Service case, And that was a case where the Court of Appeals, it was the 14th court, held that an indemnity provision on the backside of a 2-page contract, so it was essentially a 2-page contract, not a 4-page contract, that it was not conspicuous because it was the 7th of 15 unrelated provisions, all with similar headings and type. And the court also, in a footnote, pointed out that, well, that was in contrast to the disclaimer of warranty provision, which was bold and in capital letters and did stand out from the others, which is exactly like the case here. We've also cited the court, the the J.C. Penney versus Welco case, and it was one where a federal district court held that an indemnity provision with a bold heading was not conspicuous because the heading of all 27 provisions in the contract were also in bold. So nothing stood out from the other. And I want to go back to this point. When everyone's wearing red, it's not conspicuous. When everything in a contract is conspicuous, nothing is conspicuous. And this is something I talked to some of our younger lawyers about who want to put everything in a brief or a motion in bold, underlining, italicized, and it's just, you see it all over the page, page after page after page after page. And I say, when you do that, people quickly start disregarding it because it doesn't stand out. It's just all over the place.
Educate me on something, counsel, please. With regard to disclaimer of warranties, you're saying that was conspicuous. To have a valid disclaimer of warranty, does it have a similar test? It has to be conspicuous?
You know, that's a good question. So I don't want to violate the rule of answering a question that I'm not sure of the answer to. I think it does, and I think that's part of the reason that it stood out that way, and in the U.S. Rentals versus Monday Service case. But
so if that is true, then you could look at the case law regarding disclaimer of warranties and maybe by analogy apply it to indemnity?
You could, the parties haven't done that in their brief. And I hate to continue down this road and then find out when I go back to my office that I am wrong about.
Well, that's what's good about this, because sometimes it raises questions that nobody ever thought of, and I'm just kind of curious more than anything. But if anything else, your suggestion would be, they knew how to make it conspicuous. Look at the disclaimer clause.
Right, they knew exactly how to do that, and they didn't do that with respect to the indemnity provision.
Actual knowledge.
Yes.
If I remember right, you said that was not raised in there, or did I misinterpret?
We don't believe it was. It's referred to in the case law. We've cited the cases for the court that as an affirmative defense. I think it's really more a matter of avoidance technically, but it's something that needs to be pleaded. It was not pleaded by them, and it was not raised in their summary judgment response either. There was no reference to the actual knowledge exception, no reference to the body of cases.
In your view, they have to use the term actual knowledge, or can they discuss it in a way where you can infer that's what they're talking about?
Well, I would say that they need to use that term, but here, not only did they not use that term in their pleadings or in their summary judgment response, they never said that Mike Fuller had actual knowledge or notice of this indemnity provision. What they said was that he obviously read the agreement because he made changes to a couple of different provisions about credit, access to credit and credit reports and things like that on a different page of the contract. And
why can't we say that's not talking about actual knowledge? They're saying you read the agreement, you knew.
The evidence shows obviously that he read the provisions that he made changes to, and that he signed off on that page. So perhaps the court can infer that he read that page. But the test is not a could have or should have test. It's a did he have actual knowledge of the indemnity provision, and there is no summary judgment evidence in the record reflecting that he made his way to the 4th page of that agreement, that he read it, and that he knew that there was an indemnity provision and signed off on it. So
You used the phrase actual knowledge. I think the other side used the phrase actual
there,
notice. I understand that actual knowledge probably infers that you had actual notice, but the inverse may not be true. I'm curious what the law is on that
So-
distinction.
and I think they've mentioned this in the brief, that some of the cases use those terms interchangeably. I think it's the most recent Texas Supreme Court case, which is Reyes versus Storage and Processing, that I think they refer to it as the actual knowledge exception in that case. And so, and that's seems to be the most recent pronouncement on it. And so, the courts may mean those interchangeably, but the Supreme Court seems to be emphasizing, at least in that case, you have to have actual knowledge.
It seems like, though, from a summary judgment evidence perspective, there's an important distinction there on the type of evidence you would have to present. You have to present evidence that the person who signed the contract actually was aware of that provision, or is it sufficient under the actual notice provision to say, here's the contract, it speaks for itself, and you made revisions and signed it? So I'm just curious if the courts have tried to wade into that distinction.
Well, I don't think it's sufficient to say that you signed the contract, so you read it, or you're at least presumed to have read it, because if you apply that presumption, it ends up swallowing the entire conspicuousness test. So it has to be something more than that. And if you're substituting for conspicuousness, which is a requirement that it's so obvious people are going to notice, then it doesn't make a lot of sense to then say, but there's an exception, and well, you don't have to actually have noticed it. You just maybe should have noticed it or could have noticed it. So we think it's actual knowledge is the correct standard. And so for all of these reasons, we don't think it's conspicuous under the case law as a matter of law. The actual knowledge exception was not properly preserved because it wasn't pleaded, it wasn't raised in their summary judgment response. And then the evidence that they're attempting to point to is not sufficient to raise a fact issue on the actual knowledge exception. Evidence that somebody read a page of an agreement or made changes to a page of the agreement is not evidence that he read 2 pages further in and actually noticed that indemnity provision. So for all of those reasons, it's not conspicuous and it's unenforceable for that reason alone. And if the court agrees, it can stop there. But I've got a few minutes left, so I do want to mention the express negligence test. And as the court knows, and for the audience's benefit, it just says that when a party seeks indemnity from the consequences of its own negligence, that it must express that intent in specific terms within the contract's 4 corners. And the Supreme Court adopted that test in Ethel Court versus Daniel Construction because of what it decried as the practice of scriveners of these agreements of devising novel ways of drafting ambiguous provisions that concealed their true intent from the indemnitor, but left just enough of a toehold for people to come back and say, aha, this satisfies the express negligence test.
Well, don't we have that here? In the text here, it says you're going to indemnify and hold harmless the seller against any claims or liability, and then it gives some examples, and then provides an exception at the end, provided, however, buyer's duty hereunder shall not arise if the cause of the seller's sole negligence.
Well,
that seems to expressly say you're responsible for everything except for this one exception.
well, the Supreme Court has said in the Atlantic Ridgeville case that sort of sole negligence exception is not sufficient to satisfy the express negligence test, because although it may imply that that, okay, sole negligence is excluded, so partial negligence or concurrent negligence will be covered. An implied agreement is not sufficient to satisfy the express negligence test. And there's other problems before you even get there, because that last clause of the indemnity provision is what they say satisfies the express negligence test. But it is completely unclear whether that last clause modifies the two main clauses above it, both of them, or just the immediately prior clause. We have a provision here that runs on for line after line after line. It's one run-on sentence. By my count, it has 27 different commas in it. And you could read it, that last phrase, to modify the first two phrases, but is that the only reasonable reading?
Does that modify the last phrase? Does that pertain just to negligence as opposed to other types of tort causes of action?
Well, it does just refer to negligence and doesn't refer to, say, product liability and other causes of action that are implicated here. So the other problem with this indemnity provision is that there's a clause in the middle of it that begins with the phrase whether or not, or excuse me, the phrase says, or where the seller may incur as a result of any act or failure to act by the buyer, or where the seller may incur. That makes no sense at all. And they've tried to make some arguments about what it might mean, but when you read it on its face, it doesn't make sense. It's right smack dab in the middle of this indemnity provision, and that's a major problem for them. You can try to construe it and think, well, they may have meant this or they may have meant that, but once you start doing that, that's an ambiguous provision that does not satisfy the express negligence test. So,
problem with the form agreement? Is there any indication this was a form agreement, and is that part of the problems that arise with form agreements? That there may be stuff in there that we know.
There is no evidence in the record that I'm aware of about whether this was a form agreement or not, or any sort of prior history between the parties. So I see my time is up. I'll just respectfully request that the court affirm the summary judgment in favor of L.A. Fuller & Son, and I'll sit down unless you have any further questions.
I've just got one question. Obviously, ordinarily, when parties appear on a motion for summary judgment involving a contract, if a contract's ambiguous, we ordinarily would find there would be a fact question and send that back for a trier of fact to interpret what the contract means. My understanding from your argument is if there's an ambiguity in this clause here, as a matter of law, that is construed against the appellant.
Yes, the agreements are strictly construed, and I'm just saying it doesn't satisfy the express negligence test if there's an ambiguity in the contract that leaves the court with a question in its mind about whether it was intended to indemnify for Mission Clay's negligence.
Thank you, counsel. Vote.
Mr. Hollenbeck, do you agree with that last statement, that this on your side has to be unambiguous or you lose?
I agree, Mr. Chief Justice, and may it please the court. I think because this is indemnity contract and the extraordinary risk shifting that courts describe this as involving, I think if it's ambiguous, that we lose. But I don't think you can read this and conclude it's ambiguous at all. I mean, it lists loss, costs, attorney's fees, damages, expenses, claims, suits, judgments. I mean, it tries to cover the full waterfront of what might be incurred as a result of any act or failure to act by Fuller. And you take that specific phrase that they're claiming is ambiguous and they don't understand it. It says, or where MCP may incur as a result of any act or failure to act by Fuller. So it's kind of the cleanup phrase. If we forgot to list something above, and we listed a lot of different things, this means everything. And so I don't think you can look at this and go, well, we don't know what this covers, because it's so broad. But I would like to start out with the issue that the court talked about a bit, and that's the actual notice or actual knowledge issue. And courts do sometimes use those interchangeably. We did raise this below. We raised it in our summary judgment briefing, where we affirmatively moved for a partial summary judgment to find that this indemnity clause is enforceable, which the court did find.
Did you use the term actual knowledge or actual notice? One, and if you didn't, do you need to? Or should we read the document and say they provided notice that was in play?
We use the terms, and if you look at pages 14 and 15 of our reply brief, we list all the record citations where we raise this issue, both on the court reporter's record, both in the clerk's record and in the pleadings. And in our responses to Fuller's summary judgment motion, we referenced our summary judgment pleadings by incorporation fully. And so we think that this is not a waiver issue at all. In fact, what I told the trial court was that Fuller's president, Mr. Mike Fuller, was able to read, understand, and modify specific terms of the parties' agreement. He actually read the terms and modified them in his own handwriting, regardless of font size and any alleged liability issues. And so, we think this issue is joined, and that all we have to raise in response to their summary judgment motion is a fact question. And I think the fact that we have his handwriting, his initialing, making some changes to provisions of the credit agreement indicates at least a fact question of actual notice or actual knowledge of what was on the very next page. Not the back of that page, but the very next page. And keep in mind, this isn't they keep referring to this as a 4-page agreement. It's a 4-page facts document. But the first page is just a cover page. And the second page is just the application that Mr. Fuller filled out and said, here's some customers we've dealt with, you can call them, here's the name of our bank and the bank manager we work with in Amarillo, and filled all this out. And so the document itself is a credit agreement and terms and conditions. And the credit agreement says in the first sentence, there are terms and conditions that will apply to all of the transactions between us, between Mission and Fuller. And everybody knew this was going to be a big project for the city of Amarillo. There were going to be lots of purchases of pipe. No one was really sure at the beginning how much pipe was going to be necessary. And so you set this up almost like a master service agreement. We'll sell you pipe on credit. Here's the credit terms. And then these are the terms and conditions that applies to all of our sales.
If I understand your co-counsel's argument from earlier, if we take that to be true, it would mean that every provision in the general terms and conditions is conspicuous, according to your argument.
Yeah, we're not, and I'm not saying that. I don't want you to hold that every time you have a heading and it's bold, it's conspicuous. And I think the importance of cases like Mundy, importance of cases like J.C. Penney, importance of cases like Dresser. Dresser said there's no headings at all to anything. And so nobody knows where the indemnity is. Mundy, there were no headings. And in fact, the indemnity provision was buried in a clause that didn't have a heading that said indemnity. And so we're different than that. In the J.C. Penney case, as well as the Mundy case, it's on the back of an almost see-through work order or purchase order, and you've got ink from the front bleeding through to the back, so that, and they said, look, just because you have a heading doesn't get you out of the conspicuousness requirement, because if you've got a heading, but no one can really read it, because in that case it's small, light gray type, it's thin paper, there's ink and dark lines coming through. Just because you have a heading isn't enough. And I think that's the importance of those cases, to say, well, it's on the back, it's buried, it's in small font, you can't read, but we have a heading. I think that's the importance of those cases. And
what makes this different then with regard to the indemnity paragraph itself as opposed to the other? What makes that one conspicuous and the other one's irrelevant as far as their conspicuous?
This one is conspicuous because it complies with the UCC requirements, which my colleague stated earlier. It complies with Dresser's statement, and you don't have the additional factors that would make it less conspicuous, such as on the back, such as it's bleeding through on a thin form, or it's in small gray type where you can't see it. So, the cases they cite aren't single-sided documents where you can't read anything. This has a heading, it stands out. And as Dresser said, as the UCC said, for example, language in capital headings, language in contrasting type or color is conspicuous.
And I don't mean to give you a hard time, but
That's fine. I expect you to give me a hard time, that's why I'm here.
Back to my original question, which talked about the general terms and conditions. All those other paragraphs have that formatting as well. And so I'm trying to understand your argument in, are you saying the entire thing's conspicuous because it all has those headings? Or is there something unique about the indemnity paragraph that makes it different or makes it conspicuous, whereas the others may not be?
Of course, your time
Oh.
has expired, but
I'm
go
sorry.
on, please answer.
I'm sorry, I'm enjoying myself, so I'm just keep talking. The critical thing is does it comply with the UCC requirements of conspicuousness? And it does. And it's on one page, it's not on the back of a see-through. Yes, the other provisions have headings, but it doesn't take a long time to look through those headings and see, okay, well, that talks about force majeure, that talks about place of sale. It says indemnity, maybe I should read that. So it doesn't make it, as a matter of law, inconspicuous just because it has a heading and other phrases have headings. The cases where we're really worried is there's no headings, or it's buried on the back of something and you just can't read it. And one real quick, and I apologize, I know I'm out of time. The warranty disclaimer is that way because the UCC requires you to put it all bold, all caps. So that also complies with the UCC, and that's why it's set out differently, because that's a legal requirement too. Thank you very much for your time today. Unless there's any further questions, we respectfully request that you reverse the judgment of the trial court and send us back for a jury trial on the issues that we talk about. Thank you very much.
Thank you, counsel. The case is submitted and you are excused to go, but we will be in recess until this afternoon. Very quickly though. Stop playing with the drum. I understand students need to go back to school, and I'm sure you are so eager to go back to class. And you're much better at that than I was when I was your age. But if the attorneys don't mind, and if the judges don't mind, I know we have to be somewhere too. How about if you have any questions, not about the case or the outcomes or what we think,